You've already pled to this.
Yes.
I'm trying to consider conditions for you so you'll be successful. Obviously, the state doesn't want to send you to prison because if they did, they wouldn't have offered this. So, smoke what? What do you mean this is a one-time deal?
What happened with this case, the charge sensitive.
So basically, you're telling me if I send you off in the world without any treatment, you will never test positive for cocaine. All right, because I'm telling you now is the time if you need help with your drug issues, now's the time to do that.
I mean, you can give me advice.
Well, no, I mean, either you need it or you don't.
Yes,
I mean, either you're going to test positive for drugs today other than marijuana or you're not. So if we do a drug test right now, she's available to do a drug test. And I know people see the female probation officer and you think we can't get a drug test done. We just have a male come down and do it. So where are we on your UA? Is it going to be clean or is it going to be? All right. So what are you going to be positive for?
No.
And what else?
Okay.
All right. So why are we playing these games? Not telling the truth, being dishonest to the court, right?
Yeah.
Why does it take me having to get probation to waste a UA on you when everybody's agreed for you to have deferred adjudication? All you have to do is come up here and tell me what your drugs are. So how often are you using cocaine?
It's not a good idea.
How often are you using cocaine? You knew you were coming to court today and you use cocaine. So how often are you using?
No, maybe. I can't give you how often because I don't do it all the time. Let's say if you want to put something on it, maybe once a month.
All right.
He said he could pass a drug test. The judge did not believe him. She asked again. He deflected again. Then she asked a third time, direct, unblinking, how often are you using cocaine? The plea deal that would keep him out of prison was already sitting on the table, already agreed to by both sides. All he had to do was tell the truth. By the end of this video, you'll understand why judges are allowed to reopen questions a plea deal was supposed to already settle, and why lying at sentencing can cost more than the crime itself.
In 2024, CR 1902, State of Texas versus Angelo Rosado. Could I have parties announced for the record for the state?
Mike Wilkins for the state, Your Honor.
Defense?
Michael J. Sawyer.
Are you Mr. Rosado?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor, I have.
In 2024, in case CR 1902, the state of Texas brought a charge against Angelo Rosado for possession of a controlled substance, penalty group 1, less than 1 gram, a state jail felony carrying a punishment range of 180 days to 2 years, plus a fine of up to $10,000.
Appropriate places?
Yes.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Assistant Prosecutor Wilkins represented the state. Defense attorney Michael J. Sawyer represented Mr. Rosado. The presiding judge accepted a negotiated plea deferred adjudication, meaning no formal conviction would be entered as long as Mr. Rosado completed the terms of supervision. Before this hearing, Rosado was a subcontractor, someone who picked up work where he could find it, a father to 4 children ranging from 5 to 19, though he told the court he hadn't spoken to 2 of them in years.
What you say? All right. Do you have any children?
Yes.
What are their ages?
5, 15, 18, and 19.
Do they live with you?
No,
When's the last time you had contact with them?
it's been a couple of years.
Why?
My youngest lives in Louisiana with her mom. My other 2 boys are older, I'll put in their own thing. And the other one, I just don't get along with the mom, so I just.
All right. Do you pay child support?
He was already paying child support. A felony conviction would have meant the loss of his ability to work in many trades, a permanent record trailing every job application, and, as the court would later make explicit, the loss of deferred adjudication itself if he violated even one condition.
All right. Are you employed?
Dealing with this, no, I'm on.
When's the last time you had employment?
I'm a subcontractor, so I get work as it comes.
All right, I require that everyone be employed on probation.
The stakes on the table that morning were 2 years of supervised freedom against up to 2 years inside a state jail facility.
Stand up.
Yes, sir.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
The state's position was procedural and straightforward. The prosecution offered a single stipulated exhibit, no live witnesses, no cross-examination, no trial. Rosado had already signed the paperwork acknowledging he understood the charge, waived his right to a jury, waived his right to confront witnesses, and agreed to let the court decide guilt based on the paper record alone. The court reviewed the exhibit, found sufficient evidence to convict, and then immediately deferred that finding exactly as the plea agreement required. On its face, this looked like the most routine kind of hearing in the American court system, the kind that happens dozens of times a day and draws no attention at all. Most people watching a plea hearing like this assume it ends the moment the paperwork is signed. It did not end there. The judge moved into what should have been a formality, reviewing conditions of supervision, and instead turned it into a direct examination of Rosado's honesty live on the record before sentence was finalized.
Receiving SSI, or there's some reason why they can't work. You understand?
Yes.
All right, if your drug test is today, what are the results going to be?
That should be okay.
Well, why do you say you should be able to pass? Here's the thing. You've already pled to this.
This is where Texas law creates more room than most people expect. Under Texas Code of Criminal Procedure, Article 428.101, a judge granting deferred adjudication retains broad discretion to set the specific conditions of community supervision, including requiring truthful disclosure relevant to those conditions. The plea agreement itself doesn't bind the judge to silence. She can still ask questions, and the defendant's answers can still shape what conditions get imposed. The open question hanging over this exchange was simple: would Rosado tell the truth about ongoing drug use, or would he try to talk his way past a deal that was already, in practice, his to lose? The judge asked if he'd pass a drug test that day. He said he should be able to. She pressed. Why should? He didn't answer directly. She told him plainly that a positive test would not undo the plea, that the state had already agreed to keep him out of custody, and that lying now served no purpose except to insult the court's intelligence.
Obviously, the state doesn't want to send you to prison, because if they did, they wouldn't have offered this. So, smoke what? What do you mean this is a one-time deal?
What happened with this case, the charge since.
So basically, you're telling me if I send you off in the world without any treatment, you will never test positive for cocaine.
He deflected again, suggesting maybe once a month.
Okay. All right, because I'm telling you now is the time. If you need help with your drug issues, now's the time to do that. Well, no, I mean, either you need it or you don't.
Yes,
I mean, either you're going to test positive for drugs today other than marijuana, or you're not.
She asked how often he used cocaine.
Other than marijuana, or you're not. So if we do a drug test right now, she's available to do a drug test. And I know people see the female probation officer and you think we can't get a drug test done. We just have a male come down and do it. So where are we on your UA? Is it going to be clean, or is it going to be? All right. So what are you going to be positive for?
He said he couldn't say exactly because he didn't do it all the time. She asked again. He offered once a month, as if testing whether that number would satisfy her. It didn't. She asked him directly why they were playing these games. He had no answer for that either.
So why are we playing these games? Not telling the truth. Being dishonest to the court. Right?
Yeah.
Why does it take me having to get probation to waste a UA on you when everybody's agreed?
Here is what that exchange actually meant in practice. A defendant who had already secured the most lenient outcome available to him nearly jeopardized it by minimizing an admission the judge was going to require anyway, because deferred adjudication in Texas is a probationary status that can be revoked to a full 2-year sentence the moment a defendant is found dishonest or non-compliant with treatment conditions. What should have happened differently is not complicated. A properly prepared defendant walking into a plea hearing where deferred adjudication was already secured needed only to answer honestly the first time he was asked. Defense counsel's job at that moment was to have prepared his client for exactly this kind of direct judicial inquiry, since judges accepting deferred adjudication frequently use the hearing itself to assess a defendant's credibility before setting supervision terms. Rosado's hesitation cost him nothing formally. The deal held, but it cost him the presumption of good faith the judge might otherwise have extended when setting the specific terms of his supervision, terms that ultimately included 90 sober meetings in 90 days and mandatory substance evaluation. There is no formal accountability mechanism for a defendant who deflects during a plea colloquy the way there might be for an attorney or officer who mishandles evidence. The only consequence lies entirely with the person standing at the podium, in the conditions the judge chooses to impose in response to what she just heard. The defense's position throughout was that Rosado had already accepted responsibility. He'd signed every waiver stipulated to the evidence and secured a deal that kept him employed and out of custody. The state's position, implicit in offering deferred adjudication at all, was that Rosado was a low-level offender better served by supervision than incarceration, provided he complied honestly going forward. Neither side anticipated the judge's questioning would become the most consequential moment of the hearing. The unresolved question the judge alone would have to answer was this: how do you set meaningful conditions of supervision for someone who won't yet admit the scope of the problem those conditions are meant to address? The judge did not revoke the plea.
All right, this is what the court is going to do. There's a $1,500 fine that's going to be probated. He's going to do 90 sober meetings in 90 days. 2 years deferred adjudication. No unsupervised contact with minors. Who do you live with? All right, there's 120 hours community service restitution. I'm going to order parenting classes.
She set the conditions anyway: a probated fine, 90 sober meetings in 90 days, mandatory substance evaluation, no unsupervised contact with minors, proof of employment within 30 days, and monthly reporting. This ruling reflects a basic principle in supervised release: conditions exist to manage risk going forward, not to punish the defendant a second time for the underlying offense, which is precisely why judges retain discretion to shape them even after a plea is accepted. It's the same philosophy behind conditional release standards the U.S. Supreme Court addressed in Morrissey v. Wade, recognizing that supervision itself carries enough liberty interest to require basic fairness, while still leaving broad room for a judge to tailor conditions to the person in front of her. This case is not really about cocaine. It is about what happens in the gap between a deal already made and a truth not yet told. Every American who has ever sat across from a judge, a boss, or an IRS auditor knows that gap. The moment where honesty costs nothing and dishonesty costs everything, and most people gamble anyway. The court's patience here didn't erase the consequence of Rosado's evasions. It just meant the consequence showed up in the fine print of his supervision instead of in a courtroom shouting match. Next courtroom was Rosado's hesitation about his drug use, simply self-preservation from a man afraid of consequences? Or is it evidence that even a lenient plea system extracts more honesty from the powerless than it does accountability from the people supervising them? And if the latter, what would a truly honest justice system actually require of everyone in that room, not just the defendant?